Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Good morning and good evening to our friends all the way in Indiana, and also good morning to all our friends in Indonesia. Welcome to course collaboration between Faculty of Law Universitas Padjadjaran and Indiana University, Morer School of Law, supported by Indonesia Ministry of Education and Culture and Indonesia Embassy for United States of America. Firstly, I would like to introduce myself. I am Ratih Mulia. I'm a law student at Universitas Padjadjaran, and it is an honor for me to host this event. On this special occasion, I would like to welcome the Honorable Professor Poppy Rufaida, PhD, the Attaché of Education and Culture in Embassy of the Republic of Indonesia in Washington, D.C., United States of America. Good morning, Prof.
Yeah, good morning and good evening in the US.
Yes. Okay, the Honorable Professor Dr. An Chandrawulan, SALLM, as the Dean of Faculty of Law, Universitas Padjadjaran. The Honorable Dr. Asaf Lubin as an Associate Professor of Law and Fellow at the Center for Applied Cybersecurity Research, Indiana University, Morer School of Law. Good evening, sir.
Good evening. Good evening.
The Honorable Dr. Danrifanto Budianto as an Associate Professor of Law and Director of Information Technology and Intellectual Property Law, Faculty of Law, Universitas Padjadjaran. Good morning, sir.
Good morning. Good evening, Asaf, Prof. Poppy in the United States.
Okay. Today's event carries the theme of the present and future cybersecurity in international trade. Ladies and gentlemen, now it is time for opening remarks, which will be delivered by representatives of the institutions who have helped this event to be conducted today. Firstly, I would like to invite Professor Poppy Rufaida as an Attaché of Education and Culture in the Embassy of Indonesia in Washington, D.C., United States of America, to deliver her opening remarks. Professor Poppy, the floor is yours.
Thank you very much. Good morning, everyone who has already in the Zoom room, and good evening, my friend and colleague, Dr. Asaf in Indiana University, and also other friend who also from the US. We are very honored to have Dr. Asaf Lubin from Indiana University today. Indonesian Embassy has been collaborating with many universities in the US to host the webinar in various topics such as engineering, science, math, technology, and social humaniora topics. And it's been done since July 2020. So Indiana University is one of our partner university who has been very good in engagement. We have already number of students who study in this university, and the main aim of Indonesian government, particularly in the US, is to increase number of Indonesians to study in the US under a government scholarship. And as we know that in the US, many world-class university who has many topics that are really important for Indonesia, for building not only in improving the quality of education, but also in improving research topic for enhancing the development of Indonesia. As we know that number of world-class university in Indonesia now are increased very rapidly due to higher collaboration between universities, not only in the US, but also in other continents, such as in Europe, in European countries, in Australia, in Asian countries. But I believe that higher education in the US is one of most important partner for improving the quality of education, particularly in a specific topic. So today topic is really important that will be delivered by Dr. Asaf Lubin, the importance of law in cybersecurity regulation. And it is also one of the agenda that has been put by the government. And we also very happy Dr. Dan Rivanto Budianto as one of he was the professional that has been working in Ministry of Communication and Information for years. And I believe that he could bridge the gap between the needs of higher education and also the industry in harmonizing the regulation and also the problem that appear faced by Indonesia. So I also urge University of Pajajaran to prepare student and also lecturer how to prepare themselves to apply for masters of doctoral program at US University, particularly at Indiana University, using Indonesian Government Scholarship or LPDP. So LPDP currently has been sending 11,249 students to study overseas. And number of students to study in the US is one of the least number compared to UK, to Netherlands, and to Australia. So through this collaboration, we are hoping that there are some lecturer or student who will study at Indiana University. And I believe that Indiana University is one of the best law school in the US. And then you can bet that we can rely on to increase the quality of our human resource management, particularly in doing the research in the level of doctoral degree. So we would like to congratulate to the committee of this event, and then we are really looking forward for having a great collaboration with Indiana University. Thank you very much.
Thank you, Professor Poppy, for your opening remarks. Next, we would like to welcome Professor An Chandrawulan, SHLLM, to deliver her opening remarks as the Dean of Faculty of Law, Universitas Pajajaran. Professor An Chandrawulan, the floor is yours.
Terima kasih, Rati. Please allow me to give this speech in Bahasa Indonesia. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera dan Om Swastiastu. Yang terhormat Honorable Dr. Asap Lubin, yang terhormat, yang kami hormati atas pendidikan dan kebudayaan Kantor Perwakilan RI di Washington DC, Profesor Poppy Rupaidah, PhD, yang terhormat para guru besar, para dosen, para penulis, tamu undangan, serta para peserta yang berbahagia. Selamat pagi, selamat bergabung pada pembelajaran kolaboratif antar negara dengan tema The Present and Future of Cyber Security in International Trade. Mengutip pernyataan Presiden Joko Widodo dan pidato kenegaraan tahunan Majelis Permusyawaratan Rakyat peringatan HUT ke-75 kemerdekaan RI, saya ingin semua platform teknologi harus mendukung transformasi kemajuan negara. Presiden Republik Indonesia menginginkan platform teknologi digital yang berkembang dan beroperasi di Indonesia turut memberikan kontribusi dalam kemajuan bangsa dan negara. Kepala negara melihat peran media digital juga di saat ini sangat besar, terutama di tengah upaya pemerintah memutus rantai pandemi COVID-19. Peran media digital yang saat ini sangat besar harus diarahkan untuk membangun nilai-nilai kemanusiaan dan kebangsaan. Tuturnya, sektor pendidikan adalah yang terdampak secara masif di Indonesia, sehingga peran media digital menjadi sangat signifikan untuk memastikan sekaligus akselerasi proses pembelajaran tetap terselenggara pada masa COVID-19. Kementerian Pendidikan dan Kebudayaan dengan program Kampus Merdeka menjadi respon adaptif terhadap akselerasi pembelajaran pada masa pandemi COVID-19. Perkembangan yang progresif dari platform teknologi digital menjadi pengungkit program Kampus Merdeka, khususnya dalam pembelajaran hukum. Karakteristik kolaboratif dari proses pembelajaran Kampus Merdeka menjadi urgensi untuk dimulai. Diawali dengan inisiasi melalui pesan teks singkat dari rekan sesama UNPAD dari Fakultas Ekonomi dan Bisnis yang kini menjabat sebagai Atase Pendidikan dan Kebudayaan pada Kantor Perwakilan RI di Washington, yaitu Profesor Poppy Rupaidah, PhD. Kegiatan pembelajaran kolaboratif antar negara pada hari ini terwujud. Indiana University Bloomington, yaitu Malware School of Law, menjadi mitra kolaboratif sekaligus kolaboratif strategis Fakultas Hukum UNPAD dalam perkuliahan Hukum Perdagangan Internasional dan Hukum Telekomunikasi dalam media digital dengan topik The Present and Future of Cybersecurity Law in International Trade. Dr. Asap Lubin Maurer, dosen dan peneliti senior dari Maurer School of Law, akan menyampaikan materi The Future of Cybersecurity Regulation, Managing Cyber Risk in the Age of Ransomware, Data Breach, and Internet of Things. Sementara Dr. Dandrivanto Budianto, dosen dan Kepala Departemen Hukum Teknologi Informasi, Komunikasi dan Kekayaan Intelektual, Fakultas Hukum UNPAD, membawakan materi The New Kids on the Blocks, Blockchain Law. Thank you for Dr. Asap Lubin. It is an honor to have you in this lecture. Please send my high gratitude to Professor Austin Paris, Dean Maurer School of Law, and Leslie Davis, Assistant Dean for International Program, Maurer School of Law, Indiana University, Bloomington. Hopefully, this cooperation will continue in the future. Finally, for all participants, have a great time in attending these lectures. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Professor Anan, for your opening remarks. Ladies and gentlemen, before we start our discussion, please allow me to introduce the speakers for today's event. Today, we are pleased to welcome Dr. Asaf Lubin from Indiana University Moore School of Law. And Dr. Lubin will be sharing with us his expert opinion on the future of cybersecurity, regulation, managing cyber risk in the age of ransomware, data breaches, and Internet of Things. Also, we are pleased to welcome our very own Dr. Dan Rifanto Budianto, SH LLM in IT Law, FCBR from Universitas Pajajaran. Dr. Dan Rifanto is an academic expert and practitioner in information technology law, which comprises of cyber law, telecommunication law, e-commerce law, and digital economy law since 1999. His expertise in information technology law brought Dr. Dan Rifanto to be part of drafting team for law number 11 of 2008 concerning electronic information and transactionals, also known as UU ITE. Dr. Dan Rifanto has also served as special staff of the Indonesian Ministry of Communication and Information. Today, Dr. Dan Rifanto will be sharing with us his expert opinion on new kids on the block, blockchain law in Indonesia. Dr. Dan Rifanto, the floor is yours.
Thank you, Rati, for the introduction, and Professor Anan, Dean of the Faculty of Law, University Pajajaran, and also Prof. Poppy from the Attaché in Indonesian Embassy in Washington, D.C., and my brother, my colleague, Dr. Asaf Lubin. Welcome in our virtual lecture. This is a good opportunity for us, especially United States of America is not only the innovator, but also the accelerator of technology and also the ecosystem in industry with the information technology. The internet, what already is very usual, daily use for us today, is invented in the United States of America. The industry today was supported by innovation and also the collaboration between the government, the private sectors, and also the social community in United States. What we use today, the Zoom, the conference video meeting, is developed and innovated in United States of America. So Dr. Asaf Lubin, our experts, not only about the cyber law, but also in cybersecurity law. He had a long experience with the hacker, but today he turned his position in the side of legal. So this is a big opportunity for us, my proudly students and all the participants, that our prominent lecturer today, Dr. Asaf Lubin, will be sharing his knowledge, his experience, and we have around 20 minutes to have discussion after his lecturing. Asaf Lubin, please, the screen is yours.
Well, let me start by saying thank you so much. I'm honored and privileged to have the opportunity to speak to all of you today. And before I even begin my presentation, I want to extend a great degree of excitement by both the Dean of Indiana University Moore School of Law, Dean Austin Parrish, and Dean Leslie Davis, to all of you. And I know I speak for all of them, that we encourage any one of you who's considering, both professors and students, opportunities to collaborate. It's a real honor for us, an opportunity, and we'd be delighted to see the connection between Indonesia and the United States in these contexts of academic and research increase. And in particular, Indiana University Maurer School of Law is known for its rich and well-established background in cybersecurity law and regulation, which is the topic of the presentation that I will share with you today. So with no further ado, I'm going to share my screen and my slides with all of you, and hopefully we'll be able to take it from there. So in today's presentation, what I want to cover with you is a discussion about cybersecurity regulation. In essence, I want to ask the question, why is it that cybersecurity regulation is failing us so much? And what can we do to increase cybersecurity through law and through means of governmental regulation? And that is in particular in an era that I'm sure will not surprise you, where we're all witnessing increasing amounts of cyber attacks, data breaches, ransomware attacks. Before coming here, I looked at some information about Indonesia specifically. Microsoft Indonesia has recently reported its security endpoint threat report, according to which Indonesia registered the highest malware encounter rate across the Asia-Pacific region. The country also registered the second highest ransomware encounter rate across the region. So this is a problem shared by both the United States and Indonesia. Just to give you some sense, in 2017 alone, there have been 2,600,000,000 data breaches, that is data record compromises across the world. That is 82 data records being compromised every second. Another frightening figure, the FBI estimates that there are 4,000 ransomware attacks around the world every single day. These are causing massive economic losses, massive social discrepancies, business interruptions that are really causing effects on our international trade, our international business, and stand at the heart of our need to act better in ensuring cyber hygiene and cyber protection. And so if you open a newspaper today, you're likely to find some company has been hacked or some government has been hacked. It is in this context that I want to ask the question, why do we fail so much? Why, given that we know that cybersecurity is a problem, we have yet to come to an ability to regulate this space better in order to mitigate and prevent these types of ransomware attacks, data breaches, and cyber malware attacks. It is in this context that I want to start my presentation. I'll spend about 10 minutes or 15 or so discussing what is so unique about cybersecurity and why it's so hard to regulate, and then move to some solutions in how regulation can evolve in this space. So to begin, we might ask the question of what can we do in the face of a cybersecurity attack? There is a hacker who is attacking your computer today. What can a government do in order to engage that hacker, in order to prevent that attack? And so the most obvious answer is that they can take criminal civil action against this individual. In the United States, there's a federal law. It's called the Computer Fraud and Abuse Act. And there can be federal action that can be brought against that individual. However, as we know far too well, there's political and jurisdictional challenges in international cybercrime enforcement and prevention. That is to say the hacker is in Russia or in China or in North Korea, the ability of an American law enforcement agency to actually bring that individual to justice or to issue certain civil fines against that individual are extremely limited by the geographical realities that make it so impossible to send law enforcement across the ocean, so to speak, to grab that individual. In particular, when those individuals are shielded by the governments in those particular countries. And so there's, in an internet that is so non-territorial, there is a limitation that is imposed by the fact that our laws are so territorial, that there's an inability to impose our laws against hackers, against criminals who operate in the cyberspace completely free. There's also statutory challenges. That is to say, some of our laws might be outdated. Indeed, many of the cybersecurity laws that were first introduced in the late 80s, 90s, 2000s have not have not been updated to address contemporary challenges in cybersecurity. Here's one particular example, a case now pending before US courts called Facebook v. NSA Group, in which an Israeli hacking company called NSA Group has been using Facebook's servers in order to hack WhatsApp, in order to hack phones through WhatsApp, through the app WhatsApp. And in this particular case, they're hacking phones, but they're using the Facebook server. Under the Computer Fraud and Abuse Act, this will not be considered access to a Facebook device, to Facebook, the company, a computer device, because the hacking is done to individual phones. And so the victims are the individual owners of the phones and not Facebook. So when Facebook brings a legal action against NSO Group for violating the CFAA, part of the challenge is that the CFAA does not capture this particular kind of crime. We need to update our laws to address new forms of hacking and unlawful access to devices. But in addition to that, instead of the enforcement side, we can also think of other ways by which we can regulate. And that is to advance our protection, to encourage our companies to do better, to enhance their own cybersecurity, so to prevent, to fend off the hackers. And what we found is that our law is also inadequate in enhancing companies' action towards increasing their own cybersecurity. So one particular example of that is challenges for consumer action, consumer protection action. And I'll just name a couple problems in consumer protection action. That is consumers taking action against companies for ransomware, data breaches, cyber attacks. The first challenge is at least in the United States, and indeed in many places around the world, there is sectorial regulation of particular industries. So for example, in the United States, we have a couple laws like the HIPAA and COPA. HIPAA deals with health data. COPA deals with children's privacy. That is particular privacy laws for particular types of harms, but no omnibus, all-encompassing law. And so there would be particular industries in which you don't have a law to rely on in order to bring your claims before a court of law. Moreover, we have state-based regulations. So the United States is in a particular challenge because we're a federation. And so a lot of the regulation is done by each individual state. In California, we have a law called the California Consumer Privacy Act. In Illinois, there's a law that deals specifically with biometric data. But these are laws that only apply within those states. And again, if you're subject to an attack and you're not from the state where the law exists, you're limited by your ability to bring action. Another problem is that consumers are simply not aware about the cybersecurity risks that they are all susceptible to. And as technology continues to evolve, they cannot keep up with all the potential risks that might face. So one particular example that I remember from a few years ago is that everyone were downloading Pokemon Go as one particular app. And Pokemon Go was a particularly bad app in terms of privacy protections. It did not have at first good privacy policies. And yet consumers just wanted to download the app without taking the time to fully appreciate what are the potential risks that they're exposing themselves to with this new software, new app. But in addition, we're operating in a decentralized ecosystem where even if we try to protect ourselves, try to do well enough, say a company wants to introduce sufficient mechanism to protect itself, if they're operating in a global supply chain where around the world there are multiple companies from whom they trade or buy products, those products can be cyber insecure. And thereby they're opening themselves to risks by those companies not doing enough. We operated in an interconnected world where cybersecurity threats are indeed global. and your ability to protect yourself is quite limited. Finally, also federal, state, and foreign regulators have limited capacity in enforcement. So in the United States, we might talk about the FTC or state attorney generals. In Europe, there's the European Data Protection Agencies. A lot of these regulators have limited ability to take action, legal action against companies for insufficient, unreasonable cybersecurity practices. Because there's so many companies out there that are not doing enough, and they regulated, the enforcement agencies have limited capacity to tackle all those threats. And so they tend to focus on the larger companies, the companies that can sustain significant economic losses from liabilities brought in fines by these enforcement agencies, but they don't operate across the board. Now consider the even more complicated situation where the wrongdoer is not one particular hacker, but a whole government, where a government engages in hacking. Here, we come to the issue of international regulation of cybersecurity. And what you'll find is that even under international law, there is an inability to properly regulate cybersecurity. So if before we focused on domestic solutions and why they're not working, now we can talk about international solutions and why they're not working. And so one particular problem in international law is that we have failed to define what international law means in what we call below the threshold cyber operations. So instead of thinking about massive cyber attack and cyber wars, think about these attacks that come below the threshold of a use of force, which is the majority, more than 99% of all cyber attacks out there, are these operations that are focused on stealing data or manipulating servers in a way that doesn't rise to the level of warfare. The problem is that we have yet to articulate what does sovereignty or the principle of non-intervention in the domestic affairs of another state, both basic principles in international law enshrined in the United Nations Charter, mean in cyberspace, mean in an age where most of our activities are done remotely online and not offline in the physical space. Can we say that merely sending a few zeros and one to your computer results in a sovereignty violation? The reality is that countries have failed to agree, and attempts by the United Nations, including through the open-ended working group, what we call OEWG, or the UNGGE, the UN Group of Governmental Experts, have failed to come to terms on how these terms should be defined. And even where they suggested that there should be certain due diligence obligations, certain obligations on a state to ensure that from its own territory, there's no servers that are engaging in cyber attacks, even then they have failed to define what is the scope of that obligation, because states cannot possibly manage the entirety of all their networks and devices from within their state. And so there are capacity limitations on states in engaging in these kinds of global cybersecurity protections. But another challenge is also a challenge of attribution. In the age of cybersecurity, so many of these attacks can occur under the radar, when we operate anonymized through spoofing and onion routing and other tools that allow us to masquerade our identity. And in so doing, prevent the identification of the perpetrator as we're moving across servers in different locations. Governments have been facing with a significant challenge of engaging in forensic analysis in order to determine in cyberspace who is the original perpetrator and attribute correctly the act back to the state. And the reason why that's important is because even if we can conclude that a particular cyber attack is a violation of international law, without our ability to then attribute it back to, say, the United States or the UK or Russia or Germany, we're not able to efficiently hold those countries to account for their wrongful doing. Finally, there are challenges in enforcements. So one particular area that has been discussed a lot is how do we deter countries from doing these activities, especially when they feel good about acting with no liability because they are so anonymized. So what limits do we have to just saying Russia did it and That is an often cyber attribution in the United States. Russia, China, North Korea have done it. But what is the limits of just issuing some indictment against particular Chinese officials without the ability to then actually grab them and bring them to the United States to face criminal charges? In addition, there's a duality to cybersecurity. And that is particularly evident in the context of what we call zero-day vulnerabilities. So zero-day vulnerabilities are vulnerabilities in computer systems that have had 0 days since they've been disclosed, since the company was made aware that the vulnerability exists in its servers. And why does that matter? Because if there have been 0 days since then, it means that the company is simply not aware of the vulnerability, and therefore is unable to develop patches that can protect your devices from then being hacked. And so in the context of zero-day vulnerabilities, those are the particular threats that we worry about the most. We worry about them because if they're not being patched, they are the ones that can be utilized to cause all of our devices to collapse. And the issue is that governments have an interest to hoard, to collect these zero-day vulnerabilities, because then they can use them for their own intelligence gathering operations, for their own cyber operations in cyberspace. And so on the one hand, they want to eliminate these 0 days in order to protect their own devices when the attacks is done unto their citizens, but they simultaneously want to use those 0 days to attack others. And so the balance of equities, deciding when to hold the 0 day and when to disclose it to the companies so they can patch those vulnerabilities, is an ongoing challenge for governments. Finally, governments are also incentivized to engage in what we call defend forward operations. These are operations in which they want to have some presence in other countries' governmental networks. They want to do that to collect intelligence or to engage in preparedness for the moment where something bad happens. In the United States, cyber comms policies, that is called defend forward. But when you're engaging in these kinds of operations, when you're placing malware in other people's computers, those other peoples don't know that you're doing that just to protect yourself, just to protect in the case that the cyber attack will come against you. They might think that you're doing that because you're preparing for an offensive attack. And so in basic international affairs terms, we have a security dilemma problem. We have a situation where no one is sure what the other is doing, creating a cyber insecurity, creating further deterioration of the relationship between the countries. I'll mention one final problem and move to some solutions. So a last problem that I want to bring about comes from Judge Eastberg of the United States, who in 1996 wrote an article that is still very foundational in thinking about cybersecurity law. And that article is called Cyberspace and the Law of the Horse. And in that article, Judge Eastberg suggests that there is no such thing as cybersecurity law. Instead, he said, there is particular laws that may deal with cybersecurity. In the same way that there is no law of the horse, there's no law that applies to horses. There's particular fields of law, say torts or contracts or property law, that might be applicable in the context of horses. My ownership of a horse is a property law question that deals with horses. In the same way, we shouldn't talk about an overarching cybersecurity law, but we should think about the intersectionality between cybersecurity and existing traditional fields of law. Now, the reason why us in the cybersecurity space have been so critical of Judge Eastberg's analysis is because we do believe that there's this thing called cybersecurity law, that cybersecurity has reached this point that the problems it identifies are so unique that it's not just about looking at compartmentalized areas of law and thinking how they apply in cyberspace, how torts or property law applies in cyberspace. Instead, we should think more holistically about problems in cybersecurity and how law might affect their regulation. And yet, we've been slow in doing this. So even in the context of teaching cybersecurity in law schools, something that I've been doing for a very long time, we still don't have a uniform way of thinking about cybersecurity law. There's no one textbook that we all use to teach this stuff. There's no one syllabus that we all have designed in how we focus on different issues in cybersecurity. And the result is that our students, those who graduate with a cybersecurity degree, might have very different backgrounds and understanding of cybersecurity law. And so how can we expect our regulators to have a good understanding and a good capacity of how to regulate these problems if we ourselves, the educators, have not yet reached a uniform way in thinking about how to teach these materials? And so with that in mind, I want to start moving us into thinking about some solutions for cybersecurity problems. And in particular, I want to focus on one particular market solution, which is, I think, really exciting. Certainly one where there's a lot of jobs. So for those of you who are thinking about jobs after law school, that is one particular emerging area. But it's one area that is also interesting because it focuses not on governmental regulation, but rather on the markets regulating themselves. And that is cyber insurance. It is an area of law that I have focused on for about 2 years now. And I know that the word insurance might sound really, really boring to a lot of people, but I promise you that cyber insurance is a particularly exciting field and raises all the questions of policy regulation that we've talked about in one particular context. So what is cyber insurance? Cyber insurance is merely a way to transfer the risk. If we all recognize that companies are at risk of cyber attacks, companies can then buy cyber insurance in order to transfer their risk from themselves to a third party, the insurance company, in exchange for a fee, the annual premium. So they buy an insurance policy annually and thereby transfer the risk to those insurers who will be there to cover them for any losses that they might incur if they suffer a cybersecurity incident. Now, just to give you a sense, this is a booming industry in the United States. According to some estimates, there will be up to $25 billion in revenue, both in the United States and globally, from the sale of cyber insurance policies. Many countries around the world have seen an increase in the offering of cyber insurance policies by insurance companies. And they see that in part as a way to mitigate cyber risks, as a way to deal with all the economic losses that come from cybersecurity threats. Cyber insurance has a long history. It goes back all the way to the 1980s. In the 1980s, there was this other policy called Errors and Omissions, E&O policy, which was a period of time in the 1980s where a lot of computers became a common tool in industry. And so a lot of industries were worried about various technical glitches or problems. And so they bought errors and omissions policies to cover them from the perils of a computerized age. In 2000, we had the famous Bug 2K incident. I hope that most of the people in the room remember this. I don't want to feel old. The Bug 2K incident was an incident in 2000 where people were worried that the move in, especially on Microsoft computers, to 01/01/2000 will cause a crashing of all the computers around the world because they were not coded correctly to deal with that date change. And so many people rushed to buy insurance policies for the Bug 2K, one of the first earlier examples of cybersecurity insurance, insurance for the risk of a digital age. In the United States, by far the biggest and largest market for cyber insurance, we started seeing cyber insurance policies being offered beginning in 2003, after California passed the first data breach notification law, a law that required any victim of a data breach to release information to all their consumers about the data breach and to offer them credit monitoring services in the case that a data breach occurs, which cost a lot of companies a lot of money. And so they all were rushing to buy cyber insurance to cover them for their losses. But today, cyber insurance is offered by more than 500 insurers around the country in the United States, and again, has a revenue of billions of dollars. What does cyber insurance cover? Well, as every insurance policy, it covers both first-party harms and third-party harms. First-party harms are harms that you might suffer. Say, the cost that you will have from a business interruption, the inability to make revenue as a company suffering a cybersecurity attack. Or if you're suffering a ransomware, it might cover you for paying the ransom to the hackers. They might also cover you for the forensic costs incurred to investigate the cause of the breach. These are all first-party harms, harms that you as the company suffer. But there's also third-party coverage. That's coverage for the liability that you might be responsible for in the case of a data breach. So if people begin suing you for a data breach, a third-party coverage will be the coverage that you will get to pay those legal costs, to pay those fines that you might be suffering from regulatory agencies. And so cyber insurance covers you for all aspects of your cyber harm. Now, it's important to clarify that cyber insurance is not insurance for certain AI applications. So we live in an age where there's computers everywhere and where there's artificial intelligence everywhere. Say a hospital uses artificial intelligence, and say that in a particular surgery room, the AI malfunctions. There are particular medical malpractice insurance policies that might cover the hospital, but that is not cyber insurance. Cyber insurance deals with data risks that are directly the result of a cybersecurity attack against your devices. Indeed, every cyber insurance policy might define the triggering event differently, but they're all centered around the perils that come from a data-intensive world. Now, why am I talking to you about cyber insurance for so long? I'm talking to you about cyber insurance because there's an article by Omri Ben Shachar and Kai Log from 2012 in the Michigan Law Review that has really changed the way we think about insurance regulation. And that article is called Outsourcing Regulation, How Insurance Reduces Moral Hazard. And what Omri and Kyle say in that article is that insurance can play a better role in regulating safety than governments can. The idea is that insurers might be better positioned to regulate markets, security protection measures than what a government can do through top-down regulation. The thinking is that an insurance company can incentivize you, the policyholder, to do certain things because you want to reduce the cost of the insurance policy. So say you're buying a fire insurance, your insurer might tell you, well, if you train your employees by doing fire drills every 6 months, we will lower your premiums, or we will give you a higher cap. In so doing, the insurance company is incentivizing you to take certain protective measures that will be a win-win for everyone. You will have a less likelihood of a fire, and the insurance company will have a less likelihood of suffering the cost of a claim that you will bring to pay for that fire. And so the insurers who understand the markets well can identify what those measures are, model the risk most efficiently, and then compel you to develop security practices that would be better for society writ large. And the question really is whether or not insurers can do that in cybersecurity. So what I want to talk to you about is whether or not we can let the cyber insurance markets and the companies operate sufficiently alone without the government intervening through regulation. And I will argue that cyber insurance companies cannot do this alone. That there's something unique about cybersecurity, that it is really a public-private good, that it has an intersectionality between public and private that requires that public intervention in the insurance markets to ensure that cyber hygiene is practiced across the industry. And to prove that, I will talk to you about the limits of the cyber insurance market. I will show you why cyber insurers cannot do this by themselves. And in doing so, I will show you why we need governmental regulation and what governmental regulation might look like. So the first problem is the actuarial challenge of cyber insurance. I'm sure all of you have bought an insurance policy of any kind, like a car insurance policy or a renter's insurance policy for your home. If you've done that, you might have gone on a website and entered all your information so that the insurer can tailor the policy for you. We call this process the insurance questionnaire, where the insurer asks you a set of questions and you provide details that assist the insurer in preparing the policy for you, in modeling your risks in order to price the policy effectively. Now, what is interesting is that insurers in the cybersecurity context have been challenged to come up with the right questions to ask. The challenge is, how do we underwrite cybersecurity? How do we model the risks in cybersecurity? And the issue is that cyber insurance is still an emerging market. It's still a new field. And what that means is that the cybersecurity threats are still evolving. And if the threats are evolving, then the ability of the insurance companies to model this effectively is also not yet placed well. They have not collected sufficient claims data and security data in order to model the risk efficiently and be able to articulate the right questions for you, the policyholder, to identify what unique risks you might face. So here's one particular example. Here's an underwriting annual questionnaire that one insurance company has. And you can see the kind of questions they ask. And one particular question that is not really great, that is common in these insurance policy questionnaires, is, do you have a privacy policy? And do you always adhere by it? Now that question is so amorphous because everyone has privacy policies and everyone will say that they adhere by it. But the question is how and in what ways, and those questions are not sufficiently tailored to identify those unique risks. Another issue that we have is information asymmetries and risk classification problems. So the entity that knows best cybersecurity risks is the government. The government has the best ability to understand cybersecurity risks because they have massive cybersecurity agencies and intelligence apparatus that is constantly monitoring evolving threats in cyberspace. Insurance companies are not best positioned to collect the necessary information, creating an information asymmetry between the government and the intelligence agencies. Moreover, the companies who are suffering these attacks have no incentive to share information with either the insurance companies or with the government, because they are worried about their own reputational harms. And so insurance companies are stuck between two entities that are not sharing sufficient information with it. And yet the only way for the insurance companies to regulate the markets is if they understand the risk well. And so the question becomes, how do we ensure everyone has some base level understanding of the risk and how the risk evolves over time? And so there will be various solutions I'll talk about at the end of my presentation on how to solve this problem. Another common cybersecurity challenge is the cyber aggregation risk. The idea is that cybersecurity risks are global. They are not focused on a particular geographical region. So think about an earthquake. Earthquakes occur in particular geographical regions commonly, or fires occur at particular geographical regions commonly. And so if I'm an insurance company, I can diversify my portfolio by offering some policies in one area of the country where I know earthquake occurs, and then offering the same policy in an area where I know earthquakes don't occur. And that's how I am able to create a pool of money to pay the claims over time. But the reality is that in cyberspace, we are unable to do this kind of geographical zoning. The reality is that we are all subject to the same few cloud service providers. And if one of those cloud service providers fall, all of the internet comes down. Think about Amazon cloud service provider. If Amazon fell tomorrow, a lot of companies at once will suffer a business interruption. Or think about the WannaCry ransomware attack that occurred just a few years ago. One ransomware attack caused more than 300,000 computers in 150 countries to all collapse at once. The ability of a single insurance company to pay claims in such a global scale is quite limited. Another problem that we have in cyberspace is that we don't have uniform language, no standardization, and no predictability in understanding cyber risks. So one example of this is the fact that there is no one standard that everyone uses for regulating cyberspace. In fact, there are more than 30 standards for cybersecurity worldwide. CISO and ISO 27001 and NIST, these are all abbreviated terms that cybersecurity experts know very well, with various kinds of security controls that companies adopt. But there is no one particular standard that we all adhere by. And the fact that we have this alphabet soup of standards means that there is no ability for all of us to come together around one uniform practiced idea of what it is to be, to adopt reasonable cybersecurity measures. So if we don't know what is reasonable in cyberspace, what a company is required to do as a bare minimum to be cybersecurity protective, how can we expect them to meet those standards that we have yet to define? Government's inability to come together and reach these uniform standards have been one particular challenge in the regulation of cybersecurity. But in addition, we have language problems. What is a cybersecurity attack? What is cyber terrorism? What is cyber war? There's no uniform definitions here, and yet cyber insurance policies have various kinds of exclusions that are supposed to deal with these kinds of situations. So if international law and domestic law have yet to define various terms, the result is that there is lack of predictability and therefore lack of consistency in adoption of basic cybersecurity measures. I've already spoken about some of the evidentiary difficulties in cybersecurity, the inability to attribute cyber attacks. So if we're unable to attribute cyber attacks in an efficient way, that also has a challenge on us in determining who is responsible for what and assigning liability under basic frameworks of torts and insurance. All of these making it harder for insurance companies to do the job they're supposed to do in regulating markets. So one particular example I want to mention to you is a famous case now called Mondelez v. Zurich. Mondelez is a company that suffered a massive ransomware attack called NotPetya in 2018. Now, Mondelez is famous because it's the company that produces Oreo cookies that are one of the most famous cookies in America. Everyone eats Oreo cookies. And so when the cyber attack called NotPetya attacked Mondelez computer servers, all of those Oreo cookies were stuck in their warehouses across the world because they were unable to control the computers that will be used to ship and monitor shipment of those boxes of Oreo cookies. And so Mondelez lost more than $100 million from this one cyber attack. And so it went to its insurance company, Zurich Insurance, and said, Zurich, please give me money to deal with this cyber attack. And Zurich said that they would love to give them money, but under the insurance policy that they signed, there's an exclusion that says, we don't cover you in the case of war, in the case of warlike events. And it just so happened that NotPetya, according to multiple intelligence agencies, was launched by Russia against the Ukraine. And so Zurich claimed this is a war, and therefore you are not covered in this context. And the problem is that we have never defined what war means in cyberspace. There's no uniform definition of cyber war. Who says that what happened in the NotPetya incident is indeed a cyber war? And indeed, how do we know that Russia was really responsible for the NotPetya attack? Indeed, just a few intelligence agencies came out, but they have not provided any evidence to support their claims. So how do we attribute the attack back to Russia? This all goes to show you that cyber insurance is underperforming in part because we don't have uniform definitions in order to deal with these particular kind of scenarios that occur repeatedly in our cyber age. And so for the last 10 or so minutes of my presentation, what I want to do is provide some ideas on how regulation can better both our cyber hygiene across markets, but also how insurance companies can then do better to regulate the markets themselves. And I'll just talk about a couple basic ideas. The first idea is, how do we deal with these state-sponsored cyber attacks and acts of cyber terrorism? State-sponsored cyber attacks are by far the most dangerous cyber attacks around because they use those zero-day vulnerabilities that I talked about. When a government with all its resources is engaging in a cyber attack, it has far more capacity to cause a cyber catastrophe than if an individual hacker does it. In those scenarios, an insurance company will never be able to deal with all the aggregated losses that might incur if a government took action. The same is true as if we woke up tomorrow to a massive mega cyber terrorist event. Think about 9/11, but in cyberspace. If that ever occurred, again, insurance companies would not be able to cover all the losses that might occur because of the interconnectivity that is so unique to the internet age. And so in these contexts, governments will have to intervene through what we call a backstop mechanism. A backstop mechanism is a pool of money that the government makes ready and prepares in the case of a mega cyber incident, where the government says, fine, insurance companies will able to cover up until certain sum, but beyond that time, in a major incident, we prepare money to offer victims prepare for those attacks. A government that commits itself to having this pool of money in the case of a cyber incident is sending a message to the world. They're saying, we're prepared, we're ready. In so doing, the government itself is sending a strong cyber deterrence claim. They're saying to the world, don't attack us because we have developed the internal resiliency to deal with these kind of mega cybersecurity incidents. So even if you attacked our critical infrastructures, we devoted pools of money ready to help our economy deal with a situation like this. So far, very few countries have created these kinds of pools of money to deal with the threat of state-sponsored mega cyber attacks. Another issue for regulation is the insurability of ransomware attacks, of extortion payments. So for those who are not familiar with the idea of ransomware, ransomware is merely a situation where a hacker blocks all access to your data by encrypting the data. And then it says to you, if you want to gain access to your data back, I will provide you the key in an exchange for ransom, in exchange for an extortion payment. Many companies decide to pay that money because it's cheaper for them to pay the extortion than to deal with the recovery costs that will come if they had to recover on their own. The problem is that by paying the extortion money, they're incentivizing a massive criminal enterprise that will only engage in more ransomware attacks. And that is why in Indonesia, as I said, ransomware is the second biggest cybersecurity threat that the country faces, because many companies are facing these sorts of ransomware attacks and have to deal with a very uneasy problem. Do I pay the ransomware and engage in criminal activity? Or do I not pay the ransom, but then suffer all the economic costs and the time lost for the business interruption until I'm able to recover? Governments, again, can step in here to provide frameworks for how to deal with ransomware attacks, to tell their companies what are the scenarios, what factors you need to consider for deciding when or when not to pay a ransom. You might say, we will only pay a ransom where there's real risk to life or real risk to property. But in all other scenarios, we will decline to pay the ransom. And again, compelling companies to collaborate with law enforcement, not to shy away from law enforcement, which many companies do, refuse to work with law enforcement because they're worried about reputational costs. They're worried about their own criminal or civil liability. So creating frameworks to share information between the companies who suffer the attacks and the law enforcement agencies is what is necessary to enhance cybersecurity. And then telling the insurance companies when and when not to indemnify, to pay the companies who paid the ransom, so that the insurance companies have a better sense of deciding when or not to deal with these scenarios. Another thing we can talk about is cybersecurity disclosures. Now, this is an area that I have researched with a colleague of mine, Meirav Furt-Motzkin from UCLA Law School. We have collected the legal documents of 300 Internet of Things companies from around the world. And what we've looked at is how Internet of Things companies that are vendors of Internet of Things devices, which are the most vulnerable in the world to cybersecurity attacks, how they disclose to their consumers their cybersecurity practices. And what we found is that these kind of IoT companies share nothing about their cybersecurity frameworks. Very few companies feel it necessary to provide information about the basic measures that they take to enhance cybersecurity. And we argue in a paper that we're working on that cybersecurity disclosures are a necessary prerequisite for a better understanding of markets, that compelling companies to disclose information on how they engage cybersecurity will be a first step towards regulators better understanding the markets and better developing standards for dealing with particular risks across particular industries. Moreover, consumers will be better aware of cybersecurity practices if such information is shared with them, both at the ex ante stage and ex post. After they suffered a data breach, they might be able to look back at the company and see what the company had did or did not do well. Insurance companies can look at these disclosure documents and get a better sense of understanding the markets and collect that kinds of security data they need to better model risks across the industry. And so requiring companies to disclose these cybersecurity practices in their SEC filings, in their filings when they go public, when they start selling shares, could be one way by which we can demand these kinds of disclosures. And we can disclose them also in financial regulations. But so far, cybersecurity disclosures are very limited in the United States and indeed around the world. I'll mention maybe two more solutions and end there. One final solution that is probably worth considering is creating depositories of claims data. Figuring out how intelligence agencies, governmental agencies, companies share aggregated information about cybersecurity threats so that we have a better understanding of the risks, so that insurance companies can then model it better, but also so cybersecurity analytics companies can have a better grasp of what are the unique problems that are faced across industries. The challenge is, of course, who holds control of that data? How do we prevent the data being shared with hackers who might use it themselves in order to perpetrate crimes? But the idea that we need to begin thinking about information sharing for cybersecurity across government and private sector is long overdue. I'll mention one final solution, and that is the idea of cybersecurity certification. And that is a solution that is now being promoted at the European Union. And the idea here is that the government will step in by creating a certification framework for cybersecurity. That is to say that the government will pick particular vendors for whom that you will go to as a company, and they will conclude whether or not you're cybersecurity ready. They will identify unique parameters that they will examine to determine whether your company is prepared to deal with cybersecurity threats. Right now, there is, again, as I said, no uniformity around standardization. So a government stepping in and creating a certification framework, creating the idea that there is one national agency that certifies you, or particular vendors that certify you under an existing standard, becomes a first step towards a better understanding of what we need to do to deal with this ongoing threat. And with that, I will end, and I really appreciate your time. Thank you so much.
Thank you, Asaf, for the fruitful lecture that we are more have understanding the development and the progress, and also the challenging that we not also the interaction of the digital world, but also the issues and also the possibilities that a part of regulators, a part of the industry, and also the community. And for the question and answer for the discussion, we have several questions. I would like to read for you. Just a moment. From the student first. We have also the lecturers in international law and also in the cyber law department. So first, I will read from the student first. Asaf, the Insurance Information Institute, the cyber incident have become a third larger risk to business worldwide. The question is, how can we choose or separate between prevention and insurance? Because there is a legitimate debate and also a challenge that I think the organization, whether they invest their money in buying a cyber policy or to spend the money on better firewall and cyber protection. The question is from Rizky Fauzi. Please, Asaf.
Thank you so much, Rizky. I think that's a terrific question. Indeed, the problem is predominantly a problem for small to medium companies, companies that cannot afford to both buy cyber insurance and also buy cybersecurity measures, work with a cybersecurity company to prepare them in the case of a cyber attack. So that's really a Sophie's choice. How do I decide between these two alternatives? What cyber insurers have begun doing is to offer a broader frameworks where they're not only providing you an insurance policy, but they're also providing you a set of services that come along the cyber insurance policy. So they contract, the insurance company contracts with cybersecurity firms, and they say to you, if you work with our firms, we will lower your premiums. And so those cybersecurity companies might step in and they do penetration testing for you to determine if you are vulnerable to certain kinds of cybersecurity threats. Or they might do compliance checks to ensure that you meet certain cybersecurity standards. And so we call this phenomena bundling. The idea is to bundle the cyber insurance product with the cybersecurity product. But the problem is that if the cyber insurers don't know with whom to contract, who are the better providers of cybersecurity measures, they might not provide you the best products that are available on the market. And also, you might not trust the cyber insurance company to do that work for you. You might prefer to choose those companies on your own. And so those bundling solutions might not be enough for you. And we've seen many, many small to medium companies make a decision. They either go insurance or they go with their cybersecurity. And at the time, if I have to give you advice, although don't take, it's not legal advice, I'm not bound by it, but what I would suggest for you is to buy cybersecurity at the time, to buy cybersecurity measures over cyber insurance. But as cyber insurance continues to mature, there would be more and more justification to transfer that if you can only choose one.
Okay, thank you, Asaf. Next, the question is from Michael Christopher. On daily basis, our data are all under constant risk of being unlawfully exposed and disclosed. there's a standard of duty to protect and standard of protection in cybersecurity framework. Please, Asa.
Great. So when I'm not teaching cybersecurity law, what I'm teaching is torts here at Indiana University Maurer School of Law. And indeed, one of the basic questions we ask in tort law is, do we have duties of care? Do we have duties that can be breached in the case of our own negligent conduct, and that the breach is enough to hold the companies to account? And so the question is, what standards or duties of protection the companies have towards us, the consumers, and can we take action against those companies in the case of an event? And in the United States, the issue is that we as consumers don't have standing to bring many of these claims. Under US law, in many of these scenarios, especially in class action suits in mega data breach cases, if you individually did not suffer a harm because the data that was compromised did not translate into monetizable losses to you, the data subject, to you, the user, then you cannot bring a claim in US courts because you will have nothing to sue over. You didn't suffer a monetizable actual harm. You only suffered a data breach. You suffered interference with your dignity, interference with your control over your data, but you cannot articulate a particular loss. And so to deal with these kinds of standing issues so that we can develop the common law of torts, so to introduce and define these duties of care, there is a need for statutory law, for regulation that would grant consumers rights of action to go ahead and hold these companies to account, to give them standing before a court, even when they cannot articulate a monetizable loss, but collectively can nonetheless bring a class action to say society suffered a loss in the case of this data breach. The California Consumer Privacy Act is one law that steps in that direction, but we don't have federal legislation in the United States that does that. In the European Union, we have the General Data Protection Regulation, or GDPR, that does some of that work. But again, it's not by consumer action, but rather by data protection authorities who can bring those action and hold those companies to account when there are massive data breaches. So regulation is really necessary in this space.
Okay, thank you. Asaf. Next is from Agung Kurniawan. Was there any backlash from the public or the government when this insurance idea emerged? Due to this lack of knowledge, this can be interpreted as only private parties wanting to exploit loopholes in the law. Because in Indonesia, Agung think not only we will have difficulties in executing it, but also to make it acceptable for the public. So the issue is how to put the equilibrium, the balancing between the government and also the public on the case of cyber insurance. Please, Asaf.
Yeah. So another thing that I do is I work with the Israeli National Cyber Directorate, which is the Israeli National Cybersecurity Agency. And they are trying to come up with ways to regulate the Israeli cyber insurance market. They call this a cyber insurance beta site. They're trying to find a way as a government in Israel to regulate this emerging market because they believe that in so doing, they will be able to export these regulations around the world. It's a form of cyber diplomacy by regulating cyber insurance. And so they have been collaborating with insurance companies, with the private sector, with academics like me, with international agencies, with reinsurance companies, in order to come up with frameworks to regulate this industry. A lot of the recommendations that I mentioned at the end of my presentations are things that the Israeli regulator is thinking about in order to regulate this space. Israel is particularly well positioned to do something like that because it's a small country with very few insurance companies, where there's a very strong cybersecurity framework already in existence. and a very strong innovative hub for technology and cyber. But other countries have different ways to think about the regulation of insurance. And so different governments have been slow to step in and introduce regulation. They have let the insurance companies operate on their own. And where we've seen that, we might have seen various inefficiencies that can only be corrected with regulation. And so deciding when to intervene and what kind of regulatory interventions are necessary is an ongoing question for many of these governments. And many have not taken the very dramatic step that the Israeli government is thinking about right now. So it's a wait and see period as the cyber insurance markets continue to evolve.
Okay, thank you, Asaf. We have a same idea of question from Safira and also Biada Wijasanjaya. It's about the ransomware. How the government or any law enforcement agency that works on the case to gain access to the victim's personal data. Would this personal data be counted as evidence? And secondly, how is the cyber insurance can protect individually, not only about the company, but how the individual can have the future of the cyber insurance in ransomware?
So here's the first reason why you should, if you suffered a ransomware attack, why you should call law enforcement agencies. The reason is that law enforcement agencies have seen many ransomware attacks happen before. And so they might possess already the key to deal with the particular ransomware that you're suffering. And so even before they have to deal with anything else, they might just be able to share with you the key because they've witnessed it happen before. And so many companies decide to deal with this alone, and in so doing, are preventing themselves from the benefit of a collective understanding of the threat. Again, they're doing it for their own reputational loss. They're worried that they will suffer some loss if they collaborated with law enforcement. But law enforcement has an incentive to step in here because they want to ensure that they deal with this criminal enterprise well. And so the question you're asking is, how can they gain access to better deal with the problem? And the answer is that it's all a question of how much the victim is willing to collaborate with law enforcement. In many cases, the victim will say to law enforcement, listen, give me some guidelines, but then I will work with my cybersecurity firm to deal with this on my own. And so the cybersecurity firm, which by the way, many cybersecurity firms are run by former law enforcement agencies who've gone to the private sector. And so they have a good understanding of how to deal with these problems because they worked for intelligence agencies before. And so they will work with their own cybersecurity company, share all their data with them. And the cybersecurity company will do the work of negotiating with the hacker, of deciding on the ransom payment, and maybe pay the ransom. In many other cases, the company decides not to pay the ransom and instead relies on its backups to restore the networks on its own and deal with all the costs that would come from that. It's a very tricky situation. Better collaboration across all these agencies is necessary, but there's a lot of suspicion and an inability to collaborate that regulation might be able to resolve in this context.
Thank you. Thank you. So before we come back to the student question, we have Dr. Idris. He was our prominent international law lecturer and expert. The question is about cyber terrorism, Asaf. What do you think about the role of United Nations to combat the cybercrime? Is the cyber terrorism is more dangerous than conventional terrorism? What you respond, Asaf?
So we haven't yet seen cyber terrorism emerge to be the kind of threat that people fear from. Nonetheless, in the United States, the Office of the Director of National Intelligence identifies cyber terrorism as one of the biggest threats posed to the United States in the years to come. And that is because as computers become more prevalent as individuals become more familiar with them, as the capacity cost, the costs of dealing with these kinds of devices decreases, there is more and more likelihood that terrorists will turn to cyber as a way to intensify their agendas worldwide, and in order to magnify their capacity to cause havoc, to cause fear amongst the civilian publics that they're trying to target. And it is in that context that international law can play a role in dealing with this kind of threat, in the same way that international law and the United Nations have played a role in dealing with traditional terrorism. But as we've witnessed, even in the context of traditional terrorism, going all the way back to the 70s, 80s, and certainly after 9/11, the international community cannot go about dealing with this alone. Indeed, each individual state has to play its part to share intelligence information with the UN, in particular the UN counterterrorism agency under the UN Security Council, to share information in order to advance sanctions regimes, financial sanctions, travel bans, tools that can be utilized in order to prevent and mitigate the threat of cyber terrorism. Whether or not we're able to do that will depend on our ability to define these things better, to interpret our terrorism conventions in a way that deals with cyberspace. But we've been very slow in doing all these things. And so before we can think about international law solutions, it's likely that states will have to take the first step in developing domestic regulation of this issue through criminal law, tort law, insurance law, as I've been discussing throughout this presentation.
Okay. Next is from Dr. Sinta Dewi Risadi. I introduce her. She is one of our prominent data privacy expert, and also she is a part of legal drafter on personal data protection bill, which is now in our parliament, is still in discussion. The question is, what do you think of the defamation insurance, since the insurance of industry prepare the kind of insurance? So first you discuss about the cyber security insurance, and now how about defamation insurance? That is what your input or insight about this, Asaf, please.
Cyber insurance will protect data losses. Indeed, if you suffer a financial loss from a breach to your data, cyber insurance is supposed to be there to cover you for those losses. And so really, a cyber insurance can be seen as an information insurance. It's insurance protecting information. The challenge is that we've been slow to see cyber insurance offered to individual users. The kind of cyber insurance we have are offered predominantly to companies who store a lot of data. But what can you individually do to protect your information? And so what literature has been suggesting for a while now is that existing policies, say your home renter's insurance or property insurance, as that you buy as an individual, might cover you for data losses, information losses in your home. The idea would be that your existing policies could cover those losses as well. But how do we do that? Will need to evolve over time, because again, we don't have good modeling yet to articulate what is the kind of harm that you and I, that random Joe, might incur from the daily data breaches that are occurring worldwide. And until we have a better sense of that, we'll be slow to see an uptick in these kinds of information insurance policies offered to data subjects, to individual users.
Okay, we back to our student question. It's more about how the lack of security from the law enforcement that cooperation may be considered as the same? This is from Al Ghifari uh, question. So the question is how to make the corporate not same or doing cooperation with the enforcement agency because they're the lack of the maybe the cybersecurity of the system. So there is a breach of the security. How to put a same. As you know, the Indonesian person is very polite. So please, Asaf.
Yeah, that's a great question. I think it's a question law enforcement agencies have been dealing with for a very long time. Everyone is trying to be a little cautious about figuring out how to try to provide necessary tools, while at the same time being aware of the unique challenges that companies, corporations might be facing in the case of a particular incident, when they're worried about their shareholders, where they're worried about their own reputation. Um, um, there have been all kinds of solutions put forward where some law enforcement agencies say, listen, we'll give you a shield, a safe harbor from any liability. We promise not to sue you. We promise not to bring any criminal charges against you, even if you were unreasonable, only if you come talk to us before you take an action. Or they might say, listen, here's, for example, in Indiana, the state of Indiana, the attorney general here has proposed a bill that is moving forward that would give that kind of a safe harbor to any company that meets certain cybersecurity standards. It says, if you do 1, 2, 3, and the bill defines what those things are, then the attorney general of Indiana promises not to bring any charges against the corporation. So again, there's various ways by which the legislator, the regulator, the enforcement agency, or law enforcement agencies, intelligence, police, and so on, might take actions to reduce the suspicion, which is obvious in these scenarios between the companies and the governmental entities.
Okay. Next is from Farhan. The question is, for the smaller or medium-sized risk in business reputation companies, what do you think about the company will further shift focus to cyber protection, which is not including the all about the insurance agency? So how to focus to cyber protection for the small and medium company?
Yeah, today a lot of cybersecurity companies offer again, it all depends on the size of your company, the size of data you have, what kind of risks are unique to you. Um, uh, um, you need to do the basic job first as a company, a small to medium company, to map out what it is that you're worried about, to identify what unique challenges you're facing, to look around and see similar companies of your size or in your industry and what harms they incurred. And so many might get consulting services as a preliminary step before getting a better sense of what they should do next. A lot of governments are stepping in here too. For example, I mentioned again, I know Israel very well. In Israel, they are developing various tools. The Israeli National Cyber Directorate, tools that a company can use to install on their networks and test out what are the kind of risks that they're incurring, or to share some information, general information about the company, and the government will step in and say, here's what we know about your unique threats, and here's what we propose to you. A company needs to understand that in today's day and age, it's not enough to deal with fire threats or property threats from theft. You need to also deal with data threats to your computer systems, and then do the basic steps of making sure that you are resilient enough to deal with an incident if that incident occurs. And so the first and foremost responsibility will always be, even if you're a small mom and shop store somewhere, you have a first responsibility to understand what are you exposed to and take certain action to mitigate that.
Okay. Thank you, Asaf. Next is from Amru. This is more like a cyber terrorism issue. The uniformity of common language and the understanding regarding cyber terrorism on cyber insurance are the country's cybersecurity framework regulated perhaps by international organization. So the question is, there is any international organization with making a model, or maybe the law, a model of law, or maybe a framework regarding the cybersecurity framework, Asaf?
Yeah. There is no uniform definition of terrorism. We've had terrorism for dozens of years, and we still have not defined what terrorism means in international law. There's more than 20 conventions, all defining terrorism differently. And so when we move to talk about cyber terrorism, the international community has not done a good job of defining terrorism. So how can we expect it to define cyber terrorism well? The problem we're having is that we'll need to, if you're buying a cyber insurance policy today and it has a cyber terrorism coverage or exclusion, you need to do a good job in understanding your contract and understanding the policy. Read what the policies say. Indeed, it will be likely the case that various insurance companies, that various governments will over time regulate cyber terrorism differently in their own domestic legislation, in the insurance companies in their own contracts. Over time, it is possible that we'll all coalesce around one generally acceptable definition. But it's not something that we will have at this time. It's something that will happen over a long period of time. So at the immediate level, if you're in a company, if you're working for an insurance company, or if you're a legislator working for a government, you want to think about what your needs are, identify your definitions. I'm an international lawyer. I also teach international law. And yet I'm not confident that this will be the first thing that the international community will define, as they have so many challenges in regulating cyber warfare and cyber security as a matter of international regulation. So that will come late at the list of things that they have to worry about.
Okay, thank you, Asa. Two last questions from Rizky Adiva and also from Vidya Karirina Utami. This is related with your expertise as the international law expert. From Rizky, it tried to have more understanding about the cyber warfare. And from the Vidya, the cybercrime basically treat to human rights. If there is a case on e-commerce without cyber insurance, it's mean the business does not prevent human rights protection. So the question is, in cyber war related with the international law, and the second about human rights violation regarding the data protection if the company is not put or not have the cyber insurance framework. Please, Asa.
So as I mentioned, there have been multiple attempts at the United Nations level to try and reach certain consensus around cybersecurity and cyber warfare regulation. The two major processes, the UNGGE, the other one is the UN Open-Ended Working Group. Neither of those processes were successful so far in getting the majority of states, or even the cyber superpowers, to come together to agree on certain terms. Aside from that, there's been an attempt by experts, academics, predominantly led by Michael Schmidt, in the creation of what we know as the Tallinn Manual process. Tallinn Manual comes in Tallinn Manual 1.0 and 2.0. It was developed under a center at NATO called the CCDCOE, which has been an attempt to codify an understanding of customary international law in cyberspace. And yet, many countries, many governments around the world have not agreed with what has been put forward by the Tallinn Manual either. They've claimed that many of the provisions in the Tallinn Manual do not reflect agreed upon international law. So the bottom line is that both in the context of cyber warfare, the application of international law to cyber operations in times of armed conflict, and to human rights law and its application in cyber, we have not yet reached consensus around what is the proper interpretation. The job would be on interpreting bodies from the ICRC for the Geneva Conventions to human rights treaty bodies like the European Court of Human Rights or the Human Rights Committee in Geneva, to take us a step further towards coalescing around definitions, knowing that it's unlikely that governments will be the first to do the regulation here, because governments all have interests vested and are worried about reaching consensus that might result for them in certain limitations on what they can do in cyberspace. My background is in cyber espionage, intelligence operations in cyberspace. The worry is that if we regulate cyberspace too much, we will hinder on the ability of governments to engage in intelligence gathering, which they see as pivotal for their own national security. And so governments are very cautious in defining rules around sovereignty, around non-intervention, around arms attacks in cyberspace, because they're worried they would result in harms to them. And so in this space, we all have a role to play, from academics to students of international law, to governments, to companies, to try slowly over time to reach consensus of some sort around some definitions, so we have better rules of the road to prevent massive cyber economic losses.
Thank you, Asaf. It's very great to have a discussion with you, and also all the question is rising all the discussion. And please let me continue my lecture about the blockchain law. When you talk about the cybersecurity, the ecosystem of blockchain said we are the secure system on the world. And why is they they declare like that, and how we deal with the issues that some experts say the blockchain is part of the money laundering platform. So please let me continuing our lecture, Asaf.
Yeah, thank you. I'll just say one last thing. Thank you so much to everyone for your questions. They were terrific, and I really appreciate this, and I'm really looking forward to your lecture. Thank you.
Thank you, Asaf. Okay, share screen. So why I talk about the topic regarding the cybersecurity in international trade, because the blockchain revolution today is already everywhere, all around the world. I put it on the new kids on the block. The 80s generation will be knew very well the voice band called the NQTB. It's mean the blockchain is not only new, but today is almost everywhere. When you talk about the digital currency or cyber currency, or maybe Bitcoin, is part of blockchain. Now, what is the blockchain will transform the cybersecurity? This is a part of the discussion is already elaborate and very well description from Asaf. So what the outlook of 2021? Today, the digital disruption is began very fast, accelerating, and massively. In 1996, Professor Hamish McRae from Harvard, the university Dr. Asaf graduated on law, the Hamish McRae say in 2020, he already predict almost definitely correct beside the pandemic, COVID-19. So the knowledge is a king. Today, everything is information revolution. When we woke up in the morning, we're not going to the bathroom or something. We just put to updating our status in social media. We're looking someone else WhatsApp story or IG story, the Instagram story. So we now in 2020 is already predicted by Professor James McRae that the knowledge is king and information revolution. So this is something that already discussed by Asaf, that today we put everything on our smartphone is our tiny computer. All about in the SIM card is about our data, is about our analytical data, is about our information digitally put on the smallest and the tiny computer called the SIM card. When we go to the situation in the 2020, when the pandemic COVID-19 is globally impact our way of life, in only 60 seconds globally, you might look our my presentation, there is a different kind of respond today. We respond everything by our thumb to our smartphone, by the uploading the stories, posting the stories, and also the WhatsApp or sharing our posting our message. And as we are, the Indonesian is WhatsApp country, which is and also the Netflix, and not to mention the TikTok, the progressive application today, not only for entertainment, but also become the business platform from the TikTok. Next, the pandemic also give the streaming another booster. Especially Indonesian is the first on video on demand, is become around 18 decreasing than the physical media. So what is in 2021? This is a new principle and new market. So anything can be connected, will be connected. And everything will be, if the connected, so there is a endangering the security, especially in cyber security. So the next will be 5G leaders, will be have the wireless market, and the big data and also the artificial intelligence, it become more than we are expected. And this is very important about the banking industry related to the blockchain. The technological innovation will be the heart of the blood of the banking industry. So today, the fintech, the financial technology and large technology companies surely will put on this moment of the truth. The fintech ecosystem, not only in United States of America, but also in Indonesia, the fintech ecosystem is put on globally interaction. So what is the blockchain? What is the new kids on the block? Yeah, our president, Pak Joko Widodo, is already said on the annual speech in August 2020 that he would like to all the technology platform will be not only supported but a part of the transformation of the nation. The rules of digital media will be pointing one direction to developing the humanity and also nationality values, which is this is why our milestone today to have the lecturing with you, Asaf, is very important. That the blockchain will in cybersecurity will be more related, especially in the transformation of values in nationality and humanity, because the blockchain is not only about commerce or economic aspect, but also in legal and also in social society, like the voting in your country today in election weeks. And also we talk about healthcare when we go to the combating and controlling the pandemic of COVID-19, we have an issues on data, how to tracking, how to tracing, and a part of Indonesian incentive for economic affected by the pandemic, we have also the issues on when we put the support or the economic incentive from the government. So the record keeping is become vulnerable when we don't have any blockchain system and also the cyber security. And digital currency. This is something that already a part of our life. We don't have any cash again in our wallet. We have more deposit on our digital currency. We call it in Indonesia is GoPay and also OVO as a digital currency. This is very friendly. It is not promoting the GoPay. Even our Minister of Education is the founder and the CEO, former of Gojek as a GoPay owner. So next, I will put off the illustration, the typical blockchain application that you already also briefly discussed. So in Gartner survey, the value add of blockchain is incredible. There is a intra-company transaction between company and also digital cash that I already illustrate in the previous slide. Now we go to the blockchain law that we are 99%, we are a team A. Everything collected, everything analyzing, and everything monetize our data because we're using WhatsApp as a WhatsApp countries, using all the Google business. We have Google Map, we have also the Android for the OS, the operating system of our phone, Google search for everything we need to search all over the world, and also Windows application in our computer. So this is something that the data collecting is there. The data collecting is factual in daily activity. So what is blocking the blockchain? Same like the cybersecurity, the regulatory uncertainty. So this is something that we are agree in one understanding that when we put the sexy terminology like blockchain, Internet of Things, the regulatory put the object of regulation something differentiating with the oldest or the previous regulation. The articulation of technology something put the different response. So the lack of trust among users is 25%. So the most blocking the blockchain is regulatory uncertainty and the lack of trust among users. So we are agree all about the battle of digital supremacy. This is not only about the nation or the pride of the nation, but also we talk about the economic and social, almost the political supremacy. So I put that we are need the virtual jurisdiction. How to convergence the principles, the norms, the institution, and the process, which is put the virtual actor and also the action, which is legal action in virtually, but they have the impact on the virtual and factual world. So in Indonesia, we have also put the differences, but in the same understanding that the person will be identified in our electronic documents, which is what is an electronic documents, a number of our cellular phone, account in Facebook, the ID on Instagram. This is something we call the electronic documents, means this is the legal actor. And also the electronic system provider and operator is a part of legal actor and also legal entity with this respond to the electronic transaction. The electronic transaction is divided, not only we talk about the profit or the commercial transaction, but also unprofit and uncommercial transaction. Transaction in Indonesian legislation understanding is more like legal action. The legal actor who do the legal action. So we need to understanding about when we are responding the blockchain law or the next future about the technology will be impact to our life and accelerated the responsibility of the law in information technology. I call it the cyber law 1.0. This is about Lex Informatica. Means the information is almost there. The information is put everything that regulated have the system with the specific architecture, and the public order is the most important thing. And next will be the Cyber Law 2.0, which means the Lex Internetica. The use of triple W, the internet networks with the network algorithms, which is very fast and also give the global network and the acceleration of two-day platform application invented and developed by the Department of Defense of United States of America is never imagined before. So there need the law which is called, I call it Lex Internetica. And the next evolution on cyber law is Cyber Law 3.0. We call it the Lex Digital Informatica, which means the platform of application, which is already now in the smartphone, because the smartphone in Indonesia is almost using the SIM card, the tiny computer inside the smartphone. So the access will be different. It's become the establishment of digital information society to be now and the last 5 years, we have a digital economy in Indonesia that supporting our economy. So when the pandemic comes, we are still can survive by the economic digital economic, because if there is no kind of digital economic, which is the transaction, the economic distribution, the economic sharing, not in the people. So when the pandemic comes, the lockdown is become an horror for the citizen. The Indonesia is not will be today like we still have interaction with you, Asaf. So and the next, the futurical cyber law, I call it the Lex Cryptographica, is something that we talk about the self-executing, like you said, about the self-executing, about the self-regulatory between the industry and the ecosystem, that will be put on the smart contracts, and also what the slide previous about the ecosystem of the blockchain, which is this is will be the industrial revolution. So I call it the Lex Cryptographia. It's not everything about the encryption, but this is everything about crypto, Internet of Things, robotic, biometric. That's something that we have a discussion. Okay. So if we talk about blockchain, everyone won't talk about the cryptocurrency. This is only a part of blockchain. Indonesia already have the 1%, where is Japan currently 5% of cryptocurrency because you have more reliable cybersecurity. But when we talk about Turkey, Brazil, Colombia is another story of on the block. So the blockchain law is a part of blockchain reality with the legal reality. How we talk about the technical design and how the human governance. So there is at least four issues that why the blockchain law is needed or maybe not needed. Responded is but because the blockchain will be need the responsibility of legal compliance and liability, especially at as already Dr. Asaf discussion about the cybersecurity. So the sectoral legislation might prevent blockchain from unleashing their socio-economic potential in Indonesia. And the potential impact is data retention rules, especially about the anti-money laundering legislation. We are in the situation that it's not for easy to put the equilibrium, the balancing between the anti-money laundering legislation and put the blockchain into the financial regulatory. And the third, we talk about the protection of fundamental legal principles and mandatory rules is such the child abuse, material drug trafficking, and money laundering. This is the issues, especially in Asia, is today first challenge because it can be difficult to remove related content from the database because the blockchain have their own ledger, have their own platform, which is in some situation, the law enforcement have no access to their system. And the fourth, we talk about the tension between blockchain reality and legal reality. This is something that we have talked about the legal perspective, the ownership change, and is not reflected on the chain. So, what I would like to introduce in my lecture that the blockchain is something that already used on daily activities, especially in digital economy, especially on the digital currency. Without we are aware that the blockchain is will be related on the global issue, especially in international trade and cybersecurity. Jack Ma said last week that the future is digital currency because how to interaction between the international trade is not only about the national currency, which is put as a transaction on international trade, but it become a bigger platform to more efficient, massive. We talk about China, Indonesia. We talk about population with India and also the United States of America. So we talk about more specially about smart contracts. Smart contracts it doesn't mean it's like a smartphone. This is more the conceptual that how to put as a legal contract, which is how to specific case of cross-border transaction in international trade. How, like what you said, Asaf, this is about how to we talk about the jurisdiction, which is a different and various system in different countries. So national contract provision require a written contract. Almost around 80% of 90% of legal system want to have a written contract. So how we deal with the technological neutral manner on to protect the important policy for smart contract. And also the arbitration, if we're going to put on the dispute mechanism, how we deal with the smart contract arbitration mechanism. And also, one of our participants today is chairwoman on the Notary Alumni University Pajajaran, Dr. Ranti, that the smart contract and notarization, because in Indonesia, we have a system of public notary. The notary is on behalf of a government. So how do we deal with the technology and the ecosystem, which is a fully and rigid regulation on the services of notary. Different with in your country, in United States, there is more like administration notary. In Indonesia, we have a public notary. The notary on behalf the state, on government. So there is something how to apply with the technology connector manner if the notary, public notary, is on behalf government. So this is something may be necessary to revise on this rule, or at least to accommodate the new rules on smart contract. Thank you very much for the time for the student and participant, and also especially for my brother Asaf. And we will welcoming the discussion, the students, or maybe participation to be a part of our discussion. We have still have around 20 minutes to have discussion. Please, if there is any question, or you have some response, Asaf, with my presentation. Well, please welcome.
So, I mean, I'm happy to ask the first question, and then we can open it up. I'm really curious, how do you see these cross-border legal issues, the conflict of law issues in this context? So say there's some kind of digital currency like Bitcoin, who should be the primary regulator, and how do we deal with situations where different countries have different interest in regulating e-commerce based on these kinds of tools, and desire to hold the data in their territory because data is commoditized, it's worth money. We've seen this problem of conflict of laws in the information society for a while now, and I don't know if I have good solutions. So I'm curious how you think that these kinds of clashes in law can be better resolved.
Okay, thank you, Asaf. When we studying the international private law or the comparative law, we talk about the conflict of law. We have discussion, long discussion about the choice of law, choice of law. So when we talk about the industry, which is more intensively accelerated, and if they're friendly user and customer user friendly, so the the limitation of territory is become useless. So everyone will try to grab, to invest, and try to monetize without any preparation if there is a dispute, especially a legal dispute. So it become your thesis that if you talk about global interaction in cyber, in virtual jurisdiction, so we come more like the how to industry and the ecosystem put the option to have more self or like independent regulatory first, which is this is if we rely on the government, we talk about the international law system on the ratification of the treaty, or maybe the model law that's mean to like in the European Union, they have a direction for the law in the each of member of the state in European Union, or maybe the problem is like in your country there, the state law is different with the federal law. So I more believe that we have to put some principal norms to agree upon with the cross-border, or we talk about the virtual jurisdiction. So this is something which, like today, we agree upon that the security of Zoom, which is put on the platform for our lecturing. This is, you know, the Zoom, we are know the Zoom, we know the vulnerable, also the vulnerable from Eric Yuan. Now, not only a baby is already like a giant. So that's my today response, Asaf. So maybe in the future we can make some collaboration research and more deeply interaction, because our country is the biggest market for information technology, because we are more adaptively than another country. You can have every technology in Indonesia. We don't have any fanatism or huge fans of technology. Almost every new technology, if they're put to trial in Indonesia, there will be success. Zoom, before pandemic, is not well known in Indonesia. But when in the April of this year, when the pandemic declared by our government, everyone put on Zoom, like a Zoom-demic. Zoom-demic. So that's my response. Not answering, but respond. And I'm very happy. I'm very grateful to have partner to have discussion, because in your country and our country, we have a same issues, but a different response. Thank you, Asaf. So I would like to have answering the question from our student, Asaf. Please let me answer. The question from Melania Fidela Gaida. The question is, oh, it's better answer by you, Asaf. I will write it. If there is a case about someone who creates a web, that person comes from Indonesia, that he used the web to spread someone private conversation on his social media accounts, such as WhatsApp, but the web host is not in Indonesia, but from the United States, someone whose data has been violated wants to take down the website and report it. He has reported the web, but still not taken down by the host in United States of America. What can we do to the web host in the United States, and the Indonesian government cannot take down the website? Then in your opinion, there should be cooperation between Indonesian and American government. From American side first. Asaf, please.
So we were just talking about conflict of laws. That is exactly that. That's the problem. The problem is, what do we do when we have these kinds of situations where governments have legitimate interests in wanting to control data, wanting to take down a website, wanting to de-index, de-link. There's one particular famous case called Equistack v. Google in the Canadian Supreme Court. In that case, a company called Equistack in Canada had an intellectual property claim against another company called DataLink, that DataLink was violating their intellectual property and selling their product for cheaper on the internet. And so they wanted to shut them down. And so instead of suing DataLink because they couldn't find them, they decide to sue Google. And they say that Google have to de-index all the search results of DataLink from the internet. And Google goes to the Canadian courts and they say, you have no jurisdiction over me. I'm an American company. We will not take down the search results on google.com because it's in America. It's on American servers. And the Canadian Supreme Court tells Google that Canada first. All laws. There's a Canadian company here whose business are being infringed. Canada has jurisdiction here, and we can compel you, Google, to remove these sites not only from google.canada.ca, but from google.com. So what does Google do? They go to the California courts in the United States, and they ask the California courts to compel them not to comply with the order of the Canadian Supreme Court. And they get a California court to say, America first, not Canada first, America first. And that is exactly the problem we're seeing in cyberspace, is these kinds of conflicts of law around these various issues of data where there's different kinds of nexus to justify different courts to step in and claim jurisdiction. And how do we deal with these kinds of extraterritorial jurisdictional reaches requires exactly what you had suggested, which is that we come into some agreement around norms. And that will take time. That's why I asked my question, because I am also struggling with this. I'm trying to figure out, can we convince governments to agree on these issues, to develop some secondary norms around choice of law, choice of jurisdiction, choice of enforcement, so that we don't have these clashes that we're seeing creeping up again and again and again. You're muted.
Yeah, thank you. Thank you, Asaf. So in the Indonesian government, we are deeply concerned about how to more like a policy strategy. Because if we put the norms like our cyber law regulation is for the law enforcement to put on the evidence first. But when we talk about the execution, about the how to deal with the to take down the, we need to have what they call it, more cooperative and collaboration discussion with the host or the platform from the United States of America. So like we have today, the collaboration is more important than we talk about execute the norms, because the norms will be deal with the system. But if we talk about discussion like you and me, like Prof. Poppy and with the and our dean and with your dean is more like have understanding. So our minister, with my experience, the latest experience with my minister information technology, because he have the background as a businessman, not as a politician or a bureaucracy, he approach is always to talk and to have understanding how to put, when you are deal with us, you deal with our market, your industry, your more like a capital, how to capitalize the market in Indonesia. We talk about security, we talk about protection. Let's put in something that we can agree upon. That's my experience with my minister when we talk about virtual jurisdiction or the territory. Because if we talk about only the norm, the legislation or the regulation, they will become with the high-end and expensive lawyer to say, no, you cannot have any enforcement in my company. So this is something we are agree. But if we talk about the industry, about the platform, they have their own interests. The government, they have their own interests. Let's put, and it's something to protect or to have more understanding. So the next question, about data sharing. Data sharing for our, how do domestic law, international law rule with breaching of data? So all over the world, the system of cyber security or data law is more about, we talk regarding a breach of personal data. So in domestic law, international law is will be respond that if you are, the more important is if we talk about the deep fake, if we talk about the not in Google or our platform used as internet, but it's more like deep fake internet or deep internet. That is something where we are not discussing today, but maybe in the future. And next is from Halisa. Halisa, okay. I will ask about blockchain that becoming the biggest innovation since the internet, where it cannot be corrupted and altered. How can privacy rights, such a right to be forgotten, to be enforced? The right to be forgotten is the system of the that introduced in the Europe about when something is already done, maybe something that we are ashamed is, or something that uh, not again comfort with our today life. So we can ask the platform or the the application to erasing or deleting on the screen. It doesn't mean you can deleting from the data, the big data or the server deleting from the screen. So when people searching something about old data which is regarding something we are ashamed, it cannot search. But if we talk about blockchain, this is something that different. It's very, very different of platform, because it's more like everyone have ledger. If we talk about Google, we talk about centralization system platform. If we talk about the blockchain, it's about decentralization system. So no one, if one can delete or put not on the search engine or something like that, the others will still have the data. So it's about more like transparency, accountability, not about uh, the right to be forgotten. So this is a good issue, good topic for research, for your thesis or your uh, research. But in my understanding, the right to be forgotten will be have more difficulties to enforce if we talk about the blockchain, because this is a different world of algorithm. Okay, that's the last question. Before I give back to the Rati as the master ceremony, again, Asaf, please receive my gratitude and our virtual brotherhood from Indiana and University of Pajajaran. Thank you.
Thank you so much.
Silakan Rati atau Bu Laina yang mau langsung menutup kuliah kita hari ini. Terima kasih.
Baik, Pak Dan, saya langsung saja. Terima kasih atas kesempatannya. I would like to say that this is a really good starting point for a collaboration between experts at Moral Law School, Indiana University, and Faculty of Law, Universitas Pajajaran. I'm sure that all the participants get fruitful knowledge from today's lectures concerning the cybersecurity, which exists in our daily life and are still a consideration for future regulations. Thank you for Professor Popi Rufaidah, Attaché of Education and Culture, Embassy of the Republic of Indonesia in Washington, D.C., United States of America. Thank you, Professor An Chandrawulan, Dean Faculty of Law, Universitas Pajajaran, and her staffs. Thank you for the support and cooperation from Dr. Prita Amalia as Manager of Research, Innovation, and Partnership at Faculty of Law, Universitas Pajajaran, and her excellent team. Thank you again for Dr. Asaf Lubin and Dr. Dan Rifanto Budianto for excellent collabs. Please give my regards to Dean Paris and Assistant Dean Leslie from Moral Law School, Indiana University. Hopefully, this opening lecture
will open further collaborations in the fields of education, teaching, and research. Thank you very much for the active participation of all participants who have joined through Zoom and YouTube platforms. Thank you to all the organizers who have prepared this lecture. As I mentioned before, this is the opening. There will be another impressive lecture. Sorry about that. Yeah.
Mau foto bersama dulu nggak, Bu Laina?
Yes,
Dibuka
yes,
dulu
yes.
videonya.
Yeah, just a bit, as I mentioned before, this is the opening. There will be another impressive lecture in the future. See you at the next panel course. Wassalamualaikum warahmatullahi wabarakatuh. Yes, it's better for us to take a picture. Yeah,
Okay.
slide by slide. Okay, Pak Dan and Professor Asafruddin. And also we still have Prof. Poppy here. Thank you, Prof. Poppy. Ibu Dekan also, thank you. And we have Prof. Eva also, Pak Hernadi, ya. Oke, boleh dibantu oleh tim ya untuk yang pertama, slide pertama. Saya kasih aba-aba. 1, 2. Oke, gimana? Gini. 1, 2, 3. Oke, kita punya 12 slide ini. Slide kedua. 1, 2, 3. Oke, berikutnya slide ketiga. 1, 2, 3. Berikutnya slide keempat. 1, 2, 3. Ya, slide kelima. 1, 2, 3. Slide 6. 1, 2, 3. Slide 7. 1, 2, 3. Slide ke-8. 1, 2, 3. Wah, ini sayangnya yang belakang-belakang ini belum menampilkan wajah ganteng dan gelisnya ini. Slide ke-9. 1, 2, 3. Slide ke-10. 1, 2, 3. Dan terakhir slide 11. 1, 2, 3. Oke. Terima kasih sekali lagi.
Dr. Asaf, thank you the community, thank you Professor An, and thank you Dr. Dan, Rifanto, and everyone in this chat
Terima
room.
kasih Bu Poppy.
Yeah, thank you so much Professor An. Yeah.
Ya, mudah-mudahan kita ketemu lagi di in another webinar or
Yes.
in another lecture. Thank you very much, Dr. Asaf Rubin. See you
Yeah.
next session. On the next session, it's really a fabulous lecture. Yeah.
It's broaden our mind. Many homework for Indonesia and also for the for the university. Yeah, Dr. Asaf raised many important issues. Thank you so much.
Thank you so much again for the invitation. This has been wonderful. Excellent questions from everyone. Thank you.
Give my regard to your dean, please.
I will.
Okay.
I will.
Yeah.
Pak Dan, terima kasih. Bu Laina.
Bu Dekan, terima kasih.
Sama-sama Ibu Dekan.
Prof. Eva, terima kasih udah ikut
Izin
serta.
ya, ada agenda lain. Terima kasih.
Mangga Bu Dekan.
Oke, kita kembalikan ke MC, silakan.
Ya. Kita boleh live. Ya, terima kasih kita boleh live ya. Izin live. Terima kasih. Salam untuk semuanya.
Hatur nuhun Prof. Poppy.
Sami-sami Padan hatur nuhun semuanya.
Sami, Prof. Poppy.
Ya. Izin live.
Thank you so much for Dr. Dan Rifanto and Dr. Asaf Rubin, and also for Professor Poppy Rufaida and then Professor Anan for attending this discussion. For today's discussion, I'm Rati as your host for today's discussion. I would like to say once again thank you and sorry if there's some mistakes. And wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam.
Oke,
Terima kasih Rati ya, terima kasih Bu Laina, terima kasih teman-teman mahasiswa yang bantu semua ya.
Ya, oke. See you. Bye.
Bye bye Asaf. See you again.